Hello everyone, in this video lecture I'm going to talk about Industrial Dispute Act 1947 and ID Act 2010. Basically, after completing these two topics, our full syllabus for industrial relation will be completed, because I explained a lot about industrial relation in my previous lecture also. So these two lectures are, I guess, enough for industrial relation for EPFO. So now let's start with Industrial Dispute Act 1947. The two main aim of this act was to secure industrial peace and harmony, and the other aim was to ensure social justice to both the actors, who are employers and employees. Peace and harmony among employers and employees, peace and harmony among social justice for employers and employees. Okay, this is the main aim for ID Act 1947. Now, in our last lecture, we already have studied what are the types of industrial dispute. There are two types of dispute, like dispute of rights and disputes of interest. You can pen it down in all your fair notes. I'm just explaining it here in this way. Okay, so there are two types of dispute of rights and dispute of interest. And disputes, so who take care of dispute of rights? Labor courts take care of dispute of rights, and tribunal, industrial tribunals take care of the dispute of interest. This is important. You can write it down and revise it so many times so that you will not get confused in these things later. And this is mentioned in dispute of rights is mentioned in second schedule, and dispute of interest is mentioned in the third schedule of ID Act. You can do one thing. You can take a fresh paper and you can write all the schedules and section on each side of the paper. Like on one side you can write all the schedules, and in another side you can write all the sections of this act. Okay, so second schedule deals with dispute of rights, and who take care of dispute of rights? Labor courts. And third schedule contains dispute of interest, and who take care of it? That is industrial tribunal. Now this was schedule. Now the section 2A of ID Act say, Industrial Dispute Act say, if any workman is, you can write it down, if any workman is discharged, dismissal, if any workman faces discharge, dismissal, retrenchment, or any type of termination, and there is a dispute, that dispute will not be the matter of union or party. If any workman faces discharge, dismissal, retrenchment, or any type of termination, there will be dispute, and that dispute will not be the matter of party or union, and the workman can directly go to Conciliation Officer. Now here comes the word Conciliation Officer. What I dictated you was the definition for is written in section 2A of ID Act. Okay, now we got Conciliation Officer. His duties the duties of Conciliation Officer are mentioned in section 12 of ID Act. Section 12 of ID Act, Industrial Dispute Act. Okay, duties of Conciliation Officer is mentioned in section 12 of Industrial Dispute Act. Now what Conciliation Officer do? I already have told you the process of conciliation in my previous lecture. He discuss the problems of the both parties and find a solution for them. Now there is a question how to raise a dispute. Suppose in case like if anyone faces dismissal from job, like discharge, dismissal, retrenchment, I already have told you he or she can directly, that employer can directly move to towards ask Conciliation Officer for help. and in case there will the case of some disputes of rights or interest, the management or union can go to conciliation officer. Now what if the process of this conciliation fails? When the process of conciliation fails, failure of conciliation report, FOC, it stands for failure of conciliation report, is prepared and it's sent to IR desk, industrial relation desk, and this desk comes under Ministry of Labor. You can go and read about Ministry of Labor from Google. You should know a little bit about Ministry of Labor, okay? So this failure of report is sent to IR desk, that comes under Ministry of Labor. Now what this IR desk do? They will solve the matter, they will solve the issue with the help of industrial with the help of labor courts. They are actually like, there is a particular term for this labor courts, industrial tribunal cum labor court. It is somewhere you can find it written like this: CGIT, Central Government Industrial Tribunal cum Labor Court, CGIT Labor Court. It is the same thing, okay? Labor Court. So failure of report is sent to IR desk, and IR desk resolve the issue, resolve the problem with the help of Central Government Industrial Tribunal cum Labor Court. Now there are we have 17 CGIT cum labor courts in India. 17. They are 17 in number. I am dictating you. Please pen it down. So the 17 labor courts in India are New Delhi, Mumbai. There are 2 in Mumbai. You can write it in bracket, like 2 CGITs in Mumbai. Then Bangalore, Kolkata, Asansol, Dhanbad. Now in Dhanbad also we have 2 CGITs. Then Jabalpur, Chandigarh, Kanpur, Jaipur, Lucknow, Nagpur, Hyderabad, Chennai and Bhubaneswar. Now out of these 17 CGITs, 2 CGITs are the National Industrial Tribunal. Now which 2 are National Industrial Tribunal? I told you that in Mumbai we have 2 CGITs, okay? So the Mumbai 1, the first CGIT of Mumbai, and one of the CGITs of Kolkata, and one CGIT from Kolkata. These 2 are known as National Industrial Tribunal, okay? Now after the matter is referred to any of the CGITs cum labor court, the adjudication process begins, and at the end of the process the preceding officer gives the award. Now this I'm not talking about any trophy and all. That award is in terms like mostly in terms of monetary compensation or anything. It is basically related to the demand for which the dispute raised, okay? Now in the end of proceeding, an award is given by preceding officer. Now let's understand how this award is implemented. When the award is given, within 30 days, it should be published. This award should be published in Official Gazette. Where it should be published? In Official Gazette, okay? Now after the publishing of this award, within 30 days this award should be implemented. This award should be published in Official Gazette within 30 days, and After the publishing of this award in official gazette, till within 30 days it should be implemented. Now who will implement this award? It is the duty of, we already have read about conciliation officer, no? He is actually regional labor commissioner. Regional labor commissioner is the conciliation officer. Regional labor commissioner, who is the conciliation officer actually, whose decision was not satisfying for both the parties. That's why they went, failure of conciliation report goes to IR desk. So basically he is the implementing authority of this award. Regional labor commissioner will look after this award and will implement it. Okay. Now there are some provisions for strikes. See, there are some prohibitions. Prohibitions stops. It prohibits us from doing a strike. So there are some prohibitions of a strike and there are some provisions of a strike. Let's talk about this. When one can go on a strike and when they cannot go on a strike. When the case is during the conciliation of the case, no one, during the process of conciliation, adjudication or arbitration, no one can go on a strike, and after the declaration of judgment by conciliation officer, no one can go on strike within 7 days of that judgment, within 7 days of the decision of conciliation officer. After the 7 days they can go on strike. Okay, so prohibition, this comes under the prohibition. When it is prohibited, when conciliation or proceeding means arbitration or adjudication, proceeding is going on 7 days after conciliation, they cannot go on strike. After they can only go on strike after 7 days. Till the 7 days they cannot go on strike. So 7 days after the conciliation, no, after this, like when this award is implemented, after the judgment of the labor court, it takes 2 months for the implementation. So 2 months after the result from court or tribunal, or judgment from court or tribunal, judgment. Okay, and same with arbitration also, after 2 months from the arbitration, because this whole process takes 2 months, right? And when settlement is under process, these are the rules for the prohibition of strikes. Now let's talk about the provision of strikes. No one from public utility services can go on a strike without giving the employer notice of a strike. No one from public utility services can go on a strike without giving the employer notice of a strike. And that notice should be given. That notice, see, you have to listen this very carefully. The notice for demand, the notice containing the demands should be given 6 weeks before a strike. And the notice for going on a strike should be given 14 days before a strike. These are the provisions for a strike, okay, for public utility services. Now if there is any date is mentioned for the, like suppose they have demand of increment in salary, and they have mentioned a date that by August 19 we want the increment in salary, else we will go on strike. So before the expiry of the date, before expiry of the date they cannot go on strike, and after the declaration of result by conciliation officer they cannot go on strike for 7 days. Okay, 7 days after conciliation, and similarly 2 months after the declaration of result from judgment from this labor court or by arbitration process. Now we have some rules for layoff of employees. Like if there will be layoff, the employee should get compensation equals to, in case of layoff, employee should get compensation, and the compensation should be equal to 50% of salary and that of dearness allowance, 50% of dearness allowance. He should get these compensation during layoff. Fine. Now while retrenchment 1 month notice should be given. 1 month notice should be given, and 15 days of salary should be awarded to the employee as a compensation, or maybe anything, that doesn't matter. 15 days of salary should be given to the employee, right? Now when undertaking close down, these are the 3 cases. When undertaking close down, in that case compensation should be paid. Now when the undertaking is closing because of unavoidable reasons, suppose by the order of court or maybe because of bankruptcy of owner, in that case the compensation should not exceed 3 months pay of the labor. 3 months pay of the labor. Is it okay? Is there any confusion? So basically we can see that in this Industrial Dispute Act 1947 they have tried to protect the interest of laborers, right? Now like every act, there is an amendment of this act also, because with changing time people think that some modification is needed, right? So now we have to study about ID Act 2010, Industrial Dispute Act 2010, and this is the amending act. It amends ID Act 1947. Now what it says, in ID Act 1947 there is a provision that the person who are employed in supervisory capacity and draw more than 1600 per month, were excluded from the Act 1947. Okay, so now the new ceiling for it is rupees 10,000. Now the person who are employed in supervisory capacity and draw more than 10,000 per month are excluded from the Industrial Dispute Act. Okay, it does not talk about the interest of these people. Now this new bill expands what it expands the list of institutions whose disputes is to be taken care by central government. So now central government will look after the disputes of some of the institutions. Central government will look after the disputes of these institutions. Now which are the institutions we are going to talk about? The companies You can write it down. I'm dictating the companies where 51% or more share are held by central government. The first 51% or more share, like more than half share, is are held by central government. Now the second one is autonomous body. Any autonomous body owned and controlled by central government. Now central public sectors or their subsidiaries. And the fourth one is corporation set up under a law. There are many corporations that is set up under a law made by parliament. Okay. Now central government will look after the disputes in these institutions also. Now there is also provision that no employer carrying any public utility service can lock out any of his workmen without giving them notice of lockout provided within 6 weeks before locking out. Okay. Is it okay? Now in ID Act 2010, there is the provision of grievance redressal committee. Now what is grievance redressal committee? This bill requires all the industrial establishment with more than 20 workers, where the number of workers is more than 20. Workers are more than 20 in number. They need to set up a grievance redressal committee. We all know about grievance. What is grievance? That is the sense of dissatisfaction or any anger in the mind of employees. Okay. So they need to set up a grievance redressal committee. Okay, grievance redressal committee. Now this committee shall consist of up to 6 members with equal representation from employer and from the workman side. So there should be 6 members and equal representation from both sides. From employer and employed side. Okay. And there is a provision for there are 6 members of equal representation from employer and workman side, that is employed side. Okay. And with adequate representation of women. There is the provision for adequate representation of women. Okay. Now the chairperson of this committee, right, I'm dictating, please write it down. The chairperson of this committee shall be appointed alternately by employer or from among the workmen each year. Like for 1 year the chairperson is from employer side and the next year the chairperson will be from employer side. Fine. Now this committee has to reach the decision within 45 days. This committee must reach a decision on any complaint within 45 days, and workmen can appeal against the decision. Workmen can appeal against this decision to the employer, and the employer has to respond within a month. Now when worker go to the employer, when they are not satisfied with this decision, they can go to employer, and employer have to respond within 1 month of the complaint. Okay. But the existence of this type of grievance redressal committee, the existence of such committees does not affect the rights available to workmen, like the rights that they get under Industrial Dispute Acts. So this type of committee, the existence of such committee does not affect the rights available to workmen under other provisions of the act, right? Now this bill Industrial Dispute Act 2010 broadens the scope of qualification required for preceding officer. Who are the preceding officer? They were in labor courts, no? Who take care of the preceding process, who finally awards in the end of proceeding. So now who can be preceding officers? I am dictating, please write it down. Who have been Deputy Chief Labor Commissioner, who have been a Deputy Chief Labor Commissioner in Central Government or Joint Commissioner with a degree in law and at least 7 years experience in Labor Department and at least 7 year experience in the Labor Department, including 3 years as a Conciliation Officer. Okay, and also, or who have been an officer in Indian Legal Services, who have been officer in Indian Legal Service with 3 year experience in grade 3. Okay. Now all awards or settlement made by labor court or tribunal shall be executed by the relevant civil court according to the Code of Civil Procedure also. So by this lecture on Industrial Dispute Act 2010 is also completed, and I guess our whole syllabus for industrial relation is completed. Now what we need to do is, for this examination point of view, we can go through the news and every topic related to this industrial relation in current affair is very important for this examination, so let's not miss that. Okay, for more lectures on the topics of labor laws and modern history, you can subscribe my channel and get the videos directly by pressing the bell icon. You can get notification of the videos I upload on these topics. Okay, thank you.